So welcome everyone. Welcome to the China Let's Talk Business series, which is designed to be light, short, but helpful in terms of practical takeaways for your business in China. And following the success of our last two webinars, so today our focus would be on IP, intellectual property protection, and particularly for those of you who owns whether patents, trademark, or copyright. So my name is Ting Zhang, and for those who are new to Crayfish, I'm the founder and CEO of Crayfish, and we provide a holistic solution for cross-border trade and investment with a focus on China and also Southeast Asia. So we are here to help business to engage the Asian market. And right from the beginning of the concept stage, helping working out a strategy and plan, and then help to execute that. So it is with SMEs in mind, although we work with companies of all sizes. And what differentiates Crayfish from other service providers is that we are powered by digital technology in our services. We have a digital platform which is intelligent, which can provide you all kinds of services that you might need in the different stages of your engagement with China. And these services are delivered by experts. And you can see when we discuss a bit later, you can see what kind of expertise we have within the sort of Crayfish network. And the way we offer some of the services are pre-scoped, very standard services, which we will mention when we later on when we talk about like trademark registration, etc. But we also have a bespoke marketplace where you can engage the service providers, whether they are experts or individuals or companies, directly to get some projects done if you don't have a budget in mind, and that is very flexible approach. And for other issues or services that you want the tailored service, we also offer that, as well as ongoing support. So without a sort of further introduction, I wanted to now mention and introduce our speaker for today, Luna. So Luna, would you like to say hello to everyone?
Sure, thank you very much, Ting. Hello, hola, everyone. I'm very happy to be here to have some brief discussion about protecting IP in China. So now I'm going to share my screen with you. Can you see it, Ting?
Yeah, it just needs a full screen. That'd be good.
Yes. Let me see the full screen here.
Perfect.
Okay. My name is Luna Zhang. I am with Kangxin Partners. As Ting mentioned, that I have been practicing for 14, 15 years. So today, my topic is about industrial property protection in China. And I would talk about it from three sides. First is the IP basics in China. And another, I like to share with you the common issues when as a new business comer to enter into China market, what kind of common issues that you are facing. Then after, I will give you some tips for IP protection in China. So first, I like to share the IP rights, the concept of IP rights for you. So IP rights are the rights given to the persons over the creations of the creative mind. They usually give the creator an exclusive rights over his or her creation for a certain period of time. So they include, one is copyright and rights related to copyright. And another is in industrial property, which includes two domains. One is trademark and another is patent. I like to take an example here is when Apple enter into China market. So what kind of IP here today, I am more focused on the industrial property, trademark and patent they will encounter in China. So when Apple company, they create this logo and also this mark, So they already got their rights in US, in UK, maybe. But when they want to operate their business or sell the product in China market, with the rights in US and UK, they still don't have the rights in China. Why? Because there is no worldwide, we call that international treaty between each other for intellectual property protection. So when they enter into China market, what they should do first is they should also file the mark and to make sure that they have the trademark rights in China. And another, from the patent point of view, is they should do a prior art search and say, their technology will be filed in China. Their technology will be protected in China with the patent rights. And then this is the thing that for a newcomer, when they enter into China market, what they are facing and what they have to do from the very beginning. So here I introduce a little bit the trademark life cycle in China. Still take Apple as example. So what they should do, I think everyone here knows that, they should file a trademark. But before you file a trademark, maybe there are already some people else, they already filed an identical or similar trademark before your registration. So the first thing actually we need to do is not trademark registration, but trademark search to make sure your registration later, the success of your registration later will be very high. If you cannot register the mark, maybe you need to think about to change the mark, to use another mark. And another one is after your registration, you also need to monitor your trademark to protect your own rights and to renew it in every 10 years. Also, for your brand protection, those kinds of work that you need to keep your rights are always with you. And then for the patent basics, in China, there are 3 types of patents: invention patent, utility model patent, and design. Here, there is a bit different compared to European. Design in China, we treat it as patent, but in Europe, design is a trademark. So here, when we want to do a new technical solutions for a product or a process, we need to do the invention patent. So before you file the patent, you also need to choose which kind of patent that you want to file. The other way is as a foreign company or foreigner, when you make these filings, patent filings, you have a couple of options, in China. One is you just file a patent application in China directly. But this time you must use a local patent agency to handle all the filings of patents. The second option you have is file a patent application first in a foreign country. Normally it's your own country, and then file a patent application in China, claiming the priority date of your first application. The third one, actually, right now, if you want to cover a lot of countries for the patent filing, also quite common, is file an international patent application under the Patent Cooperation Treaty, PCT, we call that. And then you can select China as one of the designated states. So those are the 3 ways for filing patent. And then before, all these are the basics for the trademark and the patent in China. And now I'm going to talk about when you enter into China market for trademark and patent, what kinds of challenges or common issues that you may need to pay more attention. First, I will start with the trademark. So trademark squatters. In China, China has this reputation. There are a lot of bad faith filers who just register the brand name before before you enter into China market. So because you know, China is the first to file country, which means who is the first to file, they will give the rights to that person, regardless of other elements inside. So when you prepare to enter into China market, have operation, business operation, or selling the product, so you need to pay more attention to the trademark squatters if they already registered mark in China, registered your mark in China actually. The second one is quite related, is infringement. The infringement in China, they happen online and offline. So let's see, maybe in past 5 years, they are more active online, but before it's more offline. So right now, when you check the infringement of your trademark or even of your patent, you need to combine the two channels, online and offline. They offer you different kind of leads, and then you can find the infringers much more easily and get the information of them, how many products that they infringed, and how big their revenue is. The third common issue is Chinese language mark. I had many cases that when a foreign company, they want to register trademark in China, so they ask me, normally they like to keep their original mark, you know, the Latin word and also the local. But in China, it's very important for you to have a Chinese language mark, because you enter into the market, you want to sell your products. So your target consumers, clients, they don't master English or other language very well. They use Chinese much more often. So it is better for you to marketing your product or doing advertisement to target your Chinese customers. And then this is you know, this is a better way for you to keep your brand in China more well known among the Chinese consumers. And this is the trademark common issues that you may have. And for patent, there are something similar, like infringement happens and discovery is limited, but you should focus online and offline. Another one for patent is language. Patent application must be filed in Chinese. So trademark application also needs to be filed in Chinese, but patent application, we all know, because there are so many things related to the technical terms, to some very specific description of the technology. So language plays a very important and crucial role in patent application. Take example, some law firms, they just use translators who doesn't have the technical background to translate it. And then after they give the patent attorney to file it, which I would not recommend, because it's, like I said, it's quite important to make sure that your invention, the description of your technology is understood very well by the person who is dealing with your case. And then they must master, you know, the other language and Chinese. Then it can help your patent application when they go through the examination much more smooth, and also much more efficient when they handle the refusal of the official action. So here, patent common issues, I would particularly talk about the language issue. And then I like to give some IP protection tips in China for trademark and also patents. So for trademark tips, in China, when you start to file trademark and after you get the trademark registered, it takes around 1 year. So you need to prepare to wait. It's around 1 year. So a lot of cases is the marketing team and the product team, they are so eager to enter into China market. And then the legal person tell them they still need to wait for a little bit to clear the trademark rights here. So you need to prepare to wait. And if you already make the decision to make your business operation and sell your products in China market, you need to register as soon as possible. The third one, I talked about the Chinese language marks. This is you need to make sure when you deal with it, two things are also quite important. One is when the lawyers help you to translate the Chinese marks, because the Chinese character has such diverse meaning. So it is very important to make sure the translation is aligned with the culture of your company. And another is to make sure that you also do a trademark search for the Chinese language mark, because right now, China has the biggest trademark database, which means there are a lot of trademark already in the pool, in the database. It's more than 49 million trademarks. So there is possibility that this mark has been registered by someone else. So search here is also very important. And then the last one is always monitor, always make sure that the trademark squatters, they cannot take advantage of your rights, and also take advantage of using your mark to do the infringement. This is for trademark tips. And for patent tips, here is quite similar actually. One is conduct the search before you file the prior art search, and prepare to wait again, because for 3 types of the patent, it takes a different time, but it all takes a while. So you'd better to register as soon as possible. And another is be careful with OEM. So many companies engage at OEM in China, so conduct due diligence and draft enforceable contract to avoid dispute. So here, the licensing or other kinds of the general agreement between each other is very important. So in the end of my very brief introduction of the IP, in China, I like to have some key takeaway. The first is, as a newcomer, when you enter into China market, so you need to tailor your IP strategy to your needs. So different business schools require different approaches in IP strategy. So find people to find a local agent, a local law firm to talk to is very important for you. They will keep you safe the whole way. Then this is engaged experienced IP law firm. And the last one I mentioned a couple of times is search first and register early. Why I keep mentioning this, because I saw so many cases about they just started registering without search, and when the registration has been blocked after 1 year, and then 1 year lost, and then they have to redo all the work, but waste 1 year. So that's why I put search first and register early in the very end, because it's very important for a newcomer into China market. This is my presentation today. Thank you very much. I give this back to Ting.
Thank you. Thanks, Luna. We have received many questions. Some of them you have covered during your talk. Some of them are more specific. We've chosen some of the ones we received that's relevant, and we're going to run through them now. So I just want to say that some of the questions, and then also maybe there will also be live questions. If you have further questions in addition to those you asked when you register, then do please put them in the chat box. And we may run a few minutes longer if we have additional questions. So the first one is, Luna, are there faster routes to get patents granted in China? And do they need to be aligned with the global portfolio of patents? And also another one, I think I will ask you a number of them, all related to patents, then you can talk them through. What is the process of getting patents filed in China? And how long is it normally?
Okay, I will start from the second question. So how many types of patent I just mentioned? Actually, it totally depends the process, but there are three types of the patent: invention, utility model, and also design. Three of them. And then the process are a bit different. For invention, actually, you will go through with the preliminary examination, and then after the preliminary examination, you will be published. It takes around maybe 18 months, so it's quite a long time. And then after it has been published, and from the very beginning of the filing date to it has been granted the patent rights in China, it takes right now 2 to 3 years for invention. But for utility model, the process is much easier. So they only go through preliminary, which is also formality examination. So it takes a much shorter time, is 6 to 9 months. And for design, similar to utility model, is only preliminary examination. It takes around 4 to 6 months. And then answer the first question is about do we have in China, do we have like a faster way to get the patent rights? Yes, we do. We right now in China, we offer 2 different kinds of the process to make the patent process going faster. One is called patent prosecution highway. So basically, this one is for the filings, it is to be aligned with the global portfolio of patents, which means that you already got some filing in other country, and then after you start your filing in China. So the process is after the preliminary examination, 18 months, you will enter into the substantive examination. Normally, it needs to be waited around 9 to 10 months until this case has been assigned to an examiner. But with this PPH, patent prosecution highway, so you will avoid this 9 to 10 months waiting time to the examiner. So okay, it can save like 9 to 10 months compared to the normal way. The second type is called PE, prioritized examination. So it's similar, but it only for some company and some technology, which we call that very creativity, highest creativity technology. And the China government, China authority, they issue a list for that. So if you want to apply for this PE examination, and then the company needs to send us their technology, and then we are going to check from the list and say if it belongs to this one. And this can save like more than 1 year for the examination process.
Yeah, I guess it can itself probably takes more than a couple of minutes to explain. So perhaps we can have you in the future back talk a little bit more about the patent. As I can see, we've had quite a few questions on that. And then just moving on to the software code, one of the question was, what is the most cost-effective way to register IP in software code that is constantly updated, and it's like SaaS product?
Yes. Okay, here because the question is particularly mentioned the software code. So I have to say in China, the only way to protect software code is we call that a registration of software copyrights. So we don't use so we don't have a patent to protect its rights. The only way is this registration of software copyrights. And then, but if it's not about software code, if it's about software products, and of course that we can use patent to protect it. So compared to patent protection, the registration of software copyrights, the protection is a little bit weak. Let's see. It has some protection, but it cannot compete with the patent. But of course, because here we ask a most cost-effective way, and it is much more cost-effective.
Yes, yes, thank you. I thought it was frozen. Okay, so actually, when you talk about cost-effective way of getting this done, I just wanted to, before we move to the next question, to show people attending here today what kind of cost-effective solutions we're actually talking about. This one I want to show. This is a patent search and invention. Particularly on invention, as you can see on Crayfish platform, we do have this pre-scoped, and so you know what is involved. That it's within a week you start filing, and then also with the full support of team in China. This is a colleague from Luna's team in China. So how Crayfish works is that we have worked with our partners such as Kangxin to develop very much a product standardized, so you know how much you're paying, and you know how long it takes, and you know what you'll get, and you know who you're going to be talking to. And instead of many calls and email backwards, you can then basically just buy this, and then you can literally having immediately dialogue with Jin, who's Luna's colleague in China, to get this process started. That's the same with, for example, with trademark. I think, again, Luna mentioned it's really important that you need to get trademark search. And trademark search is one of the ones that we have here. And trademark registration, again, you have a very clear pricing and why do you need and what you need and scope of work. Again, you have the team in China that you can discuss as soon as you buy that product. So I just want to add in that for people to see when we talk about cost effective, what we mean here. Okay, so carry on with the question. Another question is about trademarks. And if trademarks have already been refused, I assume there's little point in resubmitting without changing the name entirely. This is the question.
Okay, here I think when the question talk about the name is talk about change another trademark, if I understand right. If I didn't understand right, please you know, post the question on the board again. You know, when your mark has been refused, rejected by the authority, there must be some reasons. There are basically two kinds of reasons. One is absolute ground. So the mark, because it's, let's see, it put the national name there, China, put the national name there, UK, so they will reject you. And another is like, another kind of rejection reasons is because you have some marks similar or identical to your marks, which are already existing in China trademark database. So this kind of cited marks, they blocked your registration. So if you still use the same mark to register again, obviously either you change your mark. Another way, you need to analyze each of the cited marks, how you can overcome them. Some cited marks, maybe they never use it, so you can use non-use cancellation to cancel the mark. Some of the marks, maybe they register on some certain goods and services, which didn't really block your goods and services for your mark. So there are different ways to overcome these marks. depends on different situation.
Okay, that's really good to know that. And then another one is about how can we be sure the licensee is following strictly the licensing terms in terms of confidentiality, restricting non-design in the contract. I guess this apply to maybe trademarks, but maybe on patent as well. I don't know.
Okay, because for trademark and patent for the licensing agreement, both are this is a very good question because it's quite difficult when we do the licensing agreement. So in the agreement, what we should do is maybe we should put more obligations, restrictions for how do they use the intellectual property rights for them. And another is we can do monitor initiatively and also by yourself to monitor if they use it very well, or you can also ask the people who has been licensed to report to you how they use it regularly. And another way is about punishment. So in agreement, you can put like a strong punishment and compensation in the licensing agreement to make sure that they are really concerned about the numbers that they are going to face if they break the rule later.
Okay. And also going back to another question about the patent protection. It says in secondary regions within China, what is the realism to implement patent protection in the case, for example, the third-party production? So you have the factory licensing, manufacturer under license, that kind of scenario.
Yeah, I think the people who ask this question, they have some they have some experience in China, because in China for the big cities such as Beijing and Shanghai, the intellectual property protection and also the enforcement are much more stronger than the secondary we call that secondary region or the third region. So when we really face this kind of issue in other cities or regions which doesn't have really strong IP protection, normally what we can do is first we use the territorial jurisdiction principle. So if we find any products, take example, it is even one piece sold in Beijing or Shanghai, the big city, who protect and enforce much more stronger than other places. And then we are going to use this principle to change the jurisdiction. And another also right now, China has from this year, 1st of June, 2021, and China is going to use the new amendment of the patent law, which has much higher and stronger protection for patents. So they put the compensation numbers 5 times more than before. This also gives the people, the infringers, a right to stop their infringement.
That's great. So overall, would you say how strong is the patent protection for foreign companies, particularly SMEs in China?
Let me be very frank. Compared to some developed countries, China doesn't really have the reputation of a very strong protection for IP, because the concept of IP in China is only like a little bit more than 40 years, let's see. But China right now, China authority, they are really working hard on it to stop the infringement and try to protect the rights of the foreign companies who have a business in China to attract more investment in China. Take example, as I just mentioned before, the numbers for patent infringement, the maximum is 1 million RMB for the compensation. And right now, even for punishment compensation, which means that because you are doing this infringement on purpose, and you already got a severe like result, and I will give you a punishment compensation. It makes 5 million RMB for the new law. So I think they work pretty hard on this, and
yes, so certainly. Yeah, yes, I think the 2020 the new foreign investment law came into enforcement, and that also helped basically making the legal framework more transparent, more enforceable. So it's all good news, I think. Yeah, and particularly we see Chinese company also fighting for their own intellectual property, and the court cases are very encouraging.
Exactly, with the numbers are growing, so more people, more company, they prefer to fight for their own rights.
Okay, so what? Thank you very, very much, Luna. So what we are going to do now is just very quickly. Could you see my screen of the free resources one? Yeah, is the screen on free resources? Yeah. Yes. Okay, so thank you, Luna. I would like to thank you very much for your very helpful discussion and answer the questions. I just wanted to tell everyone that we have a lot of free resources on our website, and we will put this video up there for in a couple of days, so you can access, and you can access also the video from our last weekly webinars. And we have also many blogs, articles there, which you can see as well. And we have the next session after the bank holiday, the second week after that. It's about manufacturing, particularly choosing the Chinese supplier. So we would like to see you then as well. And thank you for everyone who come today. I apologize, we take a little bit more time, but I think because we received so many questions, and would not like not to answer those. And do write to us if you have any questions as well. And thank you again, everyone. If no other questions for today, I would like to bring this to and close. And thank you, Luna, again.
Thank you, Ting. Thank you very much, everyone.
Thanks. Bye-bye.